So, good morning, everyone, and welcome to yet another version of SMS, Saturday morning sessions, or satsangs, whatever we can tell them. I think we have been told there have been many feedbacks from many members that this SMSs have been a very important treasure of the practice because some of the things that we are learning here, we are taking it away and actually implementing in our chambers or in the areas of practice. So that itself gives a huge boost to myself, Arpit ji, Venu ji, and Unni ji for driving this movement, even though we all are also quite busy. But in spite of all that, we try to find out the time, but just because of the encouragement that we get from all the group members. And we are also delighted to inform that many group members have now come forward to volunteer on their own to share the topics or the sections that they want to take up. So thanks to all the members for this. Now I'll quickly share the profile of Ashwin ji. So yes, so he's delivered more than 200 plus lectures on GST. He's invited as a paper writer at different RRCs. He also contributed articles in various professional forums like BCAS, DTPA, Kolkata, etc. He handles end-to-end compliance and support for PSUs having turnover of more than 2,500 crores. He's handling GST ITC litigation strategies. He also does GST diagnostic studies for maybe coffee and core industry, coil industry, pharma industry, media industry, freight industry, and also he handles departmental audits. But these are the formal introduction that I would like to do. But apart from this, the informal thing that I would like to share about Ashwin is that he is a dedicated student of GST law. He practiced it to the hardcore. He's really sincere. And the idea that he came up with about 74-1, about the topic that he's going to discuss today, I thought this is the topic that we should take on Valentine's Day, the day we strengthen our relationship with the department. तो तू मैं तो चलता रहता है बट आज के दिन वी विल अंडरस्टैंड how department moves and what is to be done, what are the importance of the phrases. So with this, I'll put the mic to Ashwin. And before that, I would request Arpit ji, a few words from your end, and then we'll start.
Good morning, Arup And the topic which Ashwin would be taking, uh, that is only section 74, subsection 1. And that shows the beauty of the law and also the person who would be taking the subject, that we are going into the depth of the topic for a single subsection and most probably a single word there, which would be there. And as it is said that a beauty lies in the eyes of the beholder. So the manner in which you read the law and understand the law, the better you would be able to comprehend and I have been in touch with Ashwin, and we have discussed many times many issues. And what I would like to vouch for him is that the understanding that he has and the small issues which he could understand and threadbare discuss is something which is unique to him and would be an enriching session, I believe. And I hand over the session to Ashwin for taking it ahead.
Thank you, Arupji and Arpitji. It is always an ineffable privilege to take classes to the best of the minds of a student of GST law. And in this backdrop, I made an humble attempt to dissect the key provisions of what, or the key jargons of 74 subsection 1. And before we venture into this 74 subsection 1, I would like to start with an interesting phrase, as held by the Robert Jackson, who is a famous jurist. He says that we are not final because we are infallible. We are infallible only because we are final. Why am starting with this anecdote or whatever be the the famous quote by Robert H. Jackson? An assessment which has attained finality is not conclusive of the legality. An assessment which has finality, it has attained finality, is not conclusive of the legality. An officer who has passed an order under the misconception of the law or misapplied the provisions of the law and such that the taxpayer has forgone their right to make a further appeal, the assessment has attained finality, but it doesn't mean that it is filled with legality. In this backdrop, Section 74, subsection 1, before we venture into it, I just thought of sharing where this concept of bona fides and malefides came into picture. When I try to trace the origins were from Roman law of contracts. And Roman law of contracts, there is one famous Roman lawyer. His name is Cicero. In his book, Original Roman 12 Tables, he has identified the concept of bona fides and malefides. And bona fides, in simple terms, it means mental dishonesty, negative condition. Malefides means it is a condition where the ill intent is present. And the definition of bona fides could be traced even in Section 3, Clause 22 of the General Clauses Act. So in this backdrop, while bona fides and malefides are something that we trace the origins to the Roman law, then it got imported into the Indian law. In context of taxation law, that too in context of indirect taxation, the three pillars which dealt with the provisions of bona fides and malefides, I would say, it is Section 11A of the Central Excise Act and Section 28 of the Customs Act and Proviso to 73 of Chapter 5 of the Finance Act 1994 and GST law, it is Section 73 and 74. Now, I've just made a comparison before we get into 11A, 28 and 74, the provisions of the three sections. See, 11A says, where duty of excise has not been levied or paid, or has been short levied or short paid, or erroneously refunded by reasons of fraud, collusion, any willful misstatement, suppression of fact, contravention of any provisions of the Act or rules made thereunder, with intent to evade payment of duty by any person chargeable with duty, and so on, the provision goes on. If you trace the wordings of Section 28 of the Customs Act 1962, it says where any duty has not been levied or not been paid or short paid or erroneously refunded, same by the reason of collusion, the word fraud is explicitly absent, any willful misstatement or suppression of fact by the importer or exporter shall within 5 years serve the show cause notice, and so on. If you refer to the provisions of Section 74, it employs the expression where it appears to the proper officer. I would like to place my emphasis on the expression where it appears to the proper officer. Suppose, let us take an example. Now, before that, we have to take note of the fact that the previous GST law, let it be Central Excise law or Customs law, it did not employ the expression where it appears to the proper officer. The expression is only employed in Section 74. There is a conspicuous absence. In this backdrop, before we venture into where it appears to, I just want to take up one practical case study, a simple case study. Suppose, based on data analytics, the turnover of GSTR 1 and GSTR 9 is compared by the proper officer. And on comparison, there is a material difference in turnover, let us say 380 crores is coming. And he is invoking the powers under Section 61. ASMT 10 is issued. No response is given. As a result, what the officer does, he ventures into Section 74 directly, calling the material difference as the taxpayer has clothed the taxable turnover as exempted turnover in Table 5 of Form GSTR 9. When the taxpayer were asked to submit the documents such as the bill of supply, bank statements, etc., nothing was adduced by them. And as a result, the information was sought from the taxpayer and it was not submitted. It is presumed taxpayer has nothing to do. Hence, section 74 is invoked by the proper officer. The proper officer also says there is a material difference, and while issuing the show cause notice under 74, he is categorizing the difference as a sales suppression. Is categorizing the difference as a sales suppression. And no ingredients of whatever I have told orally, nothing is present in the show cause notice except the word sales suppression. Nothing is present. There is no whisper of what, how it constituted a suppression, except for the word, two words sales suppression. Nothing is there. Nothing is being expounded by the officer. All these things I come to know only during the course of personal hearing. Now, what the officer is of the view, the language of section 74 says it appears to the proper officer. It appeared to me at the time of issuing the show cause notice, you have nothing to say. That is why I have categorized the difference as sales suppression. I am venturing into section 74 is what the officer is arguing. And when questioned about the ingredients of fraud or willful misstatement or the suppression of facts to evade tax, nothing has been, all these ingredients have not been mentioned in the show cause notice. Is coming up with the proposition. It can be recorded at the time of passing the order. It need not be present at the time of issuing the show cause notice. The two words sales suppression itself suggests the fact it appeared to me it is a case of what? A fraud or a willful, it's a case of malafide. Now, this is the question which I would like to put forth. Whether the show cause notice, which is devoid of all the ingredients, will it hold its field? Because when you are going to rely on two things, I will make a specific caution here. Section 28 does not employ the word where it appears to. And 11A4 does not employ the word where it appears to. When you are relying upon all the decisions of Customs Act and the excise law, the officer is negating all these decisions are not applicable in context of GST law because that factual matrix itself, the wordings or the language of law runs in a different dynamics. So what would be your proposition here? Whether the officer's understanding of the word appears to is seemingly correct or incorrect. You rely upon Univer Textiles, you rely upon H&M, you rely upon Anand Nishikawa, any decisions from the past law, which says there should be a specific avertments or allegations as to the fraud or willful misstatement. If the notice does not contain all these ingredients, it is not a valid show cause notice. Now the question is,
Ashwin, should we read this with the proper officer, Ashwin? Because here the word they are using it as where it appears to the proper officer.
exactly, ma'am.
So the proper officer and a proper. I think that we have to look, right?
Yes. So now the question is, I'll also add one more disclaimer. He is the proper officer in accordance with the concerned circular, and it appeared to him that this is a case of what? Sales suppression. So just because it appeared to him, can he issue a show cause notice? I am also saying, unless you are going to say the basis of what? The allegation, I am not in a position to what? Effectively come up with my submission. Is what the taxpayer is logically trying to counter. He is coming up and saying, during the course of PH, I am giving you an opportunity to defend your, the position that it is not a case of fraud. So you come up with your proposition that it is not a case of fraud. It is basically an adjudicatory fact. Let us adjudicate and decide at the time of passing the orders. It is not a jurisdictional fact. Can an officer take this sort of a proposition? It is not just the officer. I would also like to draw, this is an experience which we underwent before the Honorable Madras High Court. When we are trying to place reliance on all the decisions of the past laws, the court simply negated by saying I'm not speaking on the Madurai bench Niyama Enterprises decision. I'm speaking on the batch petition which was pending before the Madras, which is now still it is reserved for orders. It is yet to come. The question is, the judge countered us by saying, as long as it is appeared to his mind, it is enough. And whether it is a case of fraud or not a case of fraud, you make your submissions at the time of PH, let him adjudicate the issue and decide. So there was a necessity for us to deep dive into the expression what exactly the term appears to was added, in what context it was added. So when we try to when we try to do a deep dive into in what context the exactly word the appears to was added, I'm just I've copied and pasted the provisions only for reference. I've taken the same case study what I've explained as an example. So we started with the tracing the legislative history from model GST law. The model GST law, you had the similar provisions of 74 contained in 51B of the first model GST law and 67 of the second model GST law. First model GST law was given in June 16 and second model GST law was proposed in November 16. All these provisions were identically worded to what was present in 11 of the Central Excise Act. The word appears to was not present in the model GST law. But when the GST bill was introduced before the parliament and it was passed, the language of section 74, it was marked, there was an apparent difference between what was there in the model GST law and what was there in the statute books. The word where it appears to the proper officer was added. The change in language definitely suggests the fact that it is a conscious choice of the legislature to inject the expression appears to the proper officer while framing the laws under section 74. I've copied and pasted the provisions of 51, 67 and 74. 51 of model GST law, it had the expression where any tax has not been paid or short paid or erroneously refunded, where input tax credit has been wrongly availed or utilized. There is no word appears to present here. Again in section 67, the word appears to was conspicuously absent. And section 74, the word appears to is present at the time of, when the original act was passed, when the bill was passed and when the act was approved, I could find the expression appears to present in section 74 of the CGST Act. In this context, I've just copied and pasted the provisions. Now, what is the exact reason for adding the word appears to in section 74? We just, went into the additional agenda. We just, went into the minutes of the GST Council meetings. 1 minute, I'm just taking out the relevant slide. I've copied and pasted it. Okay, no problem. 1 minute. I have the, the relevant council meeting minutes. Yeah, this is the provision which is there in the 8th council meeting, additional agenda, issue number 11, amendment to the provisions of section 67 of the model GST law. As per the provisions contained in 67, the proper officer has to first establish the mentioned criteria before giving the notice. So it is clearly stated that even with the existing provisions, that is, even before the word appears to is being added or proposed as an amendment, the proper officer has to first establish the mentioned criteria. However, the 67, one of the model GST law, it is not the present GST law, the model GST law does not provide the due process for coming to the decision that such criteria exist. It is proposed to amend the such section so as to provide the due process. So this is a pertinent amendment.
Yeah.
Farooqji?
Not able to hear actually.
Yes. Ashwinji, let me call Ashwin once. What is happening?
I think due to technical reason he logged out.
Hmm.
Join.
Yes. One second. I'll just check. I think he's logged out, so let's just wait for 1 minute. Okay, I'll just speak to Ashwin 1 second. He's joined back.
I'm really sorry, sir.
No
There is
problem.
some
Ashwin,
nag in,
GST, we
nag
have
in
to
the
have, in GST, we have to have technical glitches. Because of
Sir, I'm sorry. I've connected for time being in my mobile phone.
no
Once
problem.
the Wi-Fi is fixed, I will just, transition to my laptop. Yeah. Sir, I was, may I know where the signal got disturbed, sir? May I know, like, which place?
Last 1 minute.
Yeah, last one. Got it. Sir, this is in connection with the issue number 11 of the additional agenda. So the word appears to is being added based on the amendment that is being proposed here. Now, the reasons have also been clearly stated. It is not that they have to establish the criteria, but to inject the due process clause. That is the exact word that has been adopted in the council meeting. To inject the due process clause, the word appears to is being added. Now, this leads to the next area of discussion. What is meant by injecting due process clause in context of section 74? That is what exactly I'm not using my own terms. Does not provide the due process for coming to the decision that such criteria exist is the language that is adopted here. So to inject the due process clause, the word appears to is added. Now, what does here the due process clause refers to? So again, we have to do some research here. So we referred upon some of the decisions where this word appears to emanated, not just in Indian GST law, in context of the foreign law also. We want to trace the fountainhead decision of where exactly the word appears to is being adopted. How it is relevant also, I'll try to link. Don't worry, sir, you're deviating from GST law, you are going into some other law. It is just an attempt, it's my humble attempt to disseminate what I have done what I have underwent as a process to understand section 74. I'm just sharing with you all. Here, the word appears to, when we tried to trace the decision, we found a decision of the Queen's Bench decision reported in All India England Report, Re AB 1954 to ALER 287, page 288 of the decision. What the decision said exactly? The word appears to means it's some sort of a satisfaction has to be drawn. It refers to, it connotes, the expression appears to connotes some sort of a satisfaction which the administrative authority has to draw here. Now, what is the level of satisfaction which the administrative authority has to draw here? Before that, it's a Queen's Bench decision. This Queen's Bench decision is something like a High Court decision. It even got its approval. Even it got its approval in House of Lords decision. It's like a Supreme Court decision. In the case of A versus Liverpool City Council 1981 to ALLER 385. Even in this citation, the said decision got approved. The phrase appears to, as stated in the 8th Council meeting additional agenda, not only the officer has to first establish the criteria before giving the notice, he should also have to record his satisfaction. He should also have to record his satisfaction before venturing into notice under section 74. So it has made the provisions of 74 as compared to the erstwhile law even more stringent. Even more stringent. It has added the layers of fetter to the exercise of power by the proper officer. So it is a jurisdictional condition on the part of the officer to record his satisfaction before venturing into section 74 is what we have tried to frame this argument. So the word appears to draws his support from 8th Council meeting additional agenda issue number 11, and appears to is not just the mental state of belief of the officer. It cannot be based on his conjecture or surmises. He can proceed to issue a notice. Rather, it refers to the satisfaction which the officer has to arrive, and the council meeting supports that also, that there is a due process clause is being added in section 74. As a result, the word appears to is found in the statute books. So appears to refers to is synonymous to the term what? Satisfaction. It is synonymous to the term satisfaction. It is the fountainhead decisions. We have drawn it from Queen's Bench decision, also approved by the House of Lords decision. And same decisions, it got imported. We also, we want to find the traces where it got imported into Indian GST law. Not GST law, in Indian law context, sorry. In the case of Hardeep Singh versus State of Punjab, AAR 2014 SC 1400. So this Hardeep Singh case, the word appears means it is held by the Honorable Supreme Court. The word appears means clear to the comprehension or phrase near to, if not synonymous with proved. So this decision is going to the next level. First, what is meant by appears to? It's a step-by-step process. I'll explain. First, we tried to find out why this word was explicitly added. Then we tried to decode what is the meaning of the term appears to. We relied upon the decisions of House of Lords, and we found this is the fountainhead decision. In fact, if you see the case Re AB, why it is named as Re AB, I'll also tell you. It is a case not related to taxation law at all. I'll also tell you. It is a case which protects a child who is being neglected by the family. That is why you are finding the name AB. To protect the identity of the child, the name is not given. The case law is cited as Re AB. In concerning that child, this case law is being given. There the provisions of the Children Protection Act 1948 add the word appears to, and there the Queen's Council has held that the word appears to means uh, it is satisfaction, and it has also been approved by the House of Lords decision. And followed by that, in Hardeep Singh Saini's case, now the Indian Supreme Court discuss about what is the degree of satisfaction which an officer should have. First, we are decoding the expression. Then we are now seeing what is the degree of satisfaction. It is something synonymous to what? Synonymous to more or less, not synonymous, very close to the expression brute, but it is lesser than the it is how the Supreme Court says it imparts lesser degree of probability than proof. It is something less than proven beyond doubt, something less than that. Or I'll put it this way, to draw the threshold, reason to believe has a higher threshold. Appears to is a term of a lower threshold. The degree of satisfaction need not be as good as reason to believe, or it need not be as good as proven beyond doubt. It imparts a lesser degree of proof, is what it is held in the case of Hardeep Singh Saini. Now, so what we concluded, considering the extraordinary powers that is contained in section 74, a degree of satisfaction is necessary on the part of the officer prior to the invocation of what this section 74, and how the degree of satisfaction should be. A man of reasonable prudence, how he would have recorded his satisfaction, same way he should have recorded it, is what, when a man of reasonable prudence goes through his file, will also conclude or will also concur with the opinion how he has arrived. Yes, this is a case of probably a case of a fraud or a willful misstatement or suppression of fact. Now, after having understood that there should be a satisfaction and the satisfaction should be recorded by the officer, now the next question what we had is that should the satisfaction be recorded in the notice, or whether it is enough if he has it in his case file, and when it is questioned, it has to be produced. We approach 74 completely in a different perception. All credits to the judge who made our life very difficult. So we approach the 74 in a different perception. We want to know where the appears to had its origin, then went on to decode the meaning, then went on to see what is the degree of satisfaction an officer should record, and went on to check whether it has to be recorded, the satisfaction has to be recorded in the notice or not. There we find an interesting
Ashwin?
decision. Yes, sir,
Ashwin,
please.
am I audible?
Yes,
So
sir,
if
you're
I'm
audible.
not disturbing your chain of thoughts, can I say something? If it is disturbing, I'll come in later.
No, please, sir, go ahead.
Number one thing, Ashwin, your screen is not being shared. Is it not possible through your mobile? If
Yeah,
that
1
is,
minute, sir. I'll try to relog in from my laptop. My connection is fixed. 1 minute. Let me venture into relogging from you. I'll try to relog
there's a
in from my
request from
laptop.
Or
Sonia
Ashwin, you
ma'am
can send the
also.
PPT to me. I can also share.
Sir, I'm just
Okay.
logging into my Zoom, sir. I'll also share the PPT right away.
Arupta, can we wait? We'll wait for
Yes, sir. Yes, sir. Of course.
Moving in progress.
Sir, I've logged in, sir.
I'll just make you the host. 1 second.
Yeah.
Yes. Yeah, now you can share.
Thank you, sir.
Yes, your screen is visible. Can we go to that council meeting para 11? That's
Yeah,
like
the council meeting minutes, I'm just taking them. It is yes.
Mhm.
so, sir. Here, I'd like to present a counter view to what Yusuf,
Yes, sir, please.
considering the Customs Act, Excise Act, and the change made regarding where it appears to, and concentrating on this issue number 11. So this para, it's a very small para. It says, as per the present provision in 67, the proper officer shall have to first establish the mentioned criteria before giving notice. So my counter view is that, in fact, they have diluted it. They have not made it more stringent. So it is being said that as it existed earlier in the model law, based on the earlier laws, the proper officer first needed to establish even before giving the notice.
Correct.
Now the amendment or the words added are that how to have that process that he has already established.
Correct.
Since that is not there, so they have added, and it now the words are it appears to. So it
Correct.
appears to, like we are understanding, and you're also sharing your thoughts. It's a little less than reason to believe,
Correct.
and reason to believe is even more, or say not more. It is lesser than even the establishing the fact that whatever fraud, etc., is that is there. So it is
Yes.
1 degree lesser than that. So
Yes.
they themselves are saying in the first line that as per the provision, the officer has to first establish that there has been so and so fraud, etc., whatever it is, even before giving the notice. Now, how to establish that? They have said it just that it appears to the officer is sufficient. He should not have a reason to believe, and he should not have established it already before giving the notice.
Understood.
So
Yes,
that
sir.
is my counter view, sir.
Yeah.
Yeah, thank you, sir.
Sir, I agree with the dichotomy in the language. As you rightly pointed out, the word establish means something that he has to prove. That is the language that has been adopted in the first line. Whereas in the second line, it says it doesn't provide for due process for coming to the decision. So to inject the due process clause, the amendment is proposed. The amendment says where it appears to the proper officer. Now, on contextually reading all the three phraseologies, in my humble view, the word establish should not be read so rigidly to understand that it has to be proven beyond doubt. Some sort of the material, the word appears to, precisely, that is my even the second thought process here. It suggests twin connotations. There are two persons. One is the observed, another one is the observer. The observer is the proper officer, and observed is the material. What the proper officer has to do, he has to apply his mind to the material in hand and arrive at a conclusion, is what the holistically on reading the intent behind the amendment it suggests. So in my humble view, what I am trying to see on reading holistically the provisions, he has to arrive at a certain degree of satisfaction, which can be less than a proof, which can be less than a reason to believe. But at the same time, it suggests twin connotations. One, there are two things are there. One is the material, another one is the observer. Material is the observed. He has to apply his mind and arrive at the conclusion.
Sir, a slightly differ. My view is slightly differ. See, if you read the act as a whole, see,
Correct.
starting is investigation, adjudication, and order. See,
Correct.
three different steps that needs to be followed before determining a tax.
Correct.
First is the reason to believe. Then they can initiate an investigation or inspection or search under 67. Once they did that, then they will gather additional evidence.
Correct.
Then comes section 74. See, I totally agree with the judgment where they said it is little bit less than an evidence to prove, but
Yeah.
it cannot be less than reason to believe. It should be in between reason to believe, appears to, then evidence to conclude. So according to my view, it cannot be less than reason to believe.
Understood.
Ashwinji,
Yes. Yes, sir.
when we read section 73,
Yes.
we have to see the context where it appears to the proper officer. Now, on a bare reading, we can understand it in two manners.
Yes.
The first is where it appears to the proper officer. So,
appears, I would be reading in the context. He might be sure, he might not be sure. That sometimes we casually say it appears to me that it would rain.
Correct.
So I'm not sure. It might rain, it might not rain.
Correct.
This is the first context in which the appears can be read. That
Correct.
he is not sure that ITC has been wrongly availed or not, but he has the apprehension that it might have been wrongly availed.
Wonderful. Correct.
This is the first way I can read this appears.
Correct.
And the second way, when I read it, is in context of the pre-GST law which you have given and the GST Council meeting agenda which you have given,
Yes.
that there are 5 criteria on which a notice can be issued. The
Correct.
first, ITC wrongly availed, utilized, tax not paid, short paid, and refund erroneously granted. So
Correct.
this has to be established.
Correct.
There is no doubt, and which was in the pre-GST regime also, that this has to be established. But
Got
the issue was that a notice is received that you have wrongly availed ITC and this is the amount of ITC, and you have to show cause that why it should not be reversed. This
Correct.
is the process, in my opinion, which the previous law was saying. Now, by inserting appears, they are not saying that the officer can issue a notice even if he is not sure. They are only saying that you have to establish, but additionally you have to give the process also, that how
Correct.
you have established it.
Mr. Yes.
So how you have established it, I can put it in different context, that how it has to be established. Like we have seen a Guwahati High Court judgment wherein they have said that the return based issue can only be made through section 61 and then 73. So this appears in case of a return based discrepancy has to be linked with section 61. If
Correct.
there is an investigation under section 67(1), this appears has to be read in context with the section 67(1) process. Now take an example that I am an officer, I receive a letter, alert circular from another officer
Got it.
from other state. Now I have a letter which says that the person falling in your jurisdiction is not present and he is not existent, so you have to create a demand. So what I would do, I would take the letter, I would issue a notice, and I'll hold him non-existent and create a demand. But then this appears would not put it in the correct way. What he has to do is, when he receives the alert circular, he himself has to give his opinion that how it appeared that on the basis of the circular, the assessee was a non-existent. And that's why what we have seen the jurisprudence, that you cannot have a borrowed satisfaction.
Wonderful.
Because if you are relying on a letter, it is not appearing to you, it is appearing to someone else, and you are basing your opinion on that alert circular. So when I read appears, when it appears to the proper officer, that means there has to be a subjective satisfaction by the officer himself. It cannot be a borrowed satisfaction from another officer. Because if that would have been the case, the section would have been framed where it appears to the proper officer on an alert circular or any information being received. And that's why, like give an example, a practical example which we are facing and where we have raised this specific ground. So, an inspection was carried out against Mr. X at Delhi and he was held non-existent. A alert circular was issued to all the officers who have supplied goods to Mr. X, stating that they have supplied the goods to Mr. X and therefore they also should be, demand should be created against them. Upon that, so supposedly Y was supplying to X, so demand was created against Y. Then another alert circular was issued that whoever is supplying to Y, they also should be, a demand should be created against them also, because ultimately these goods have reached to X, who is non-existent. So a demand was created against Z. So Z was supplying to Y, Y was supplying to X, and we were handling the case of Mr. Z. And there was a penalty under section 122(1)(2) that you have issued invoice but no underlying supply.
Got it.
When the alert circular was attached as a relied upon document, so what we did is we checked the registration status of Mr. X, because the entire proceeding in the alert circular was based upon X, that he is non-existent. So we checked the registration status. Now Mr. X was active.
Hmm.
and he has filed his return up to December 2025.
Hmm.
So we base the ground that
Hmm.
when the alert circular, and interestingly, whenever we read the alert circular, it never says that you have to create a demand. It only at the end of the alert circular, it always say that it has to be verified.
Correct.
So that means if Mr. X is in existence, my officer cannot create a demand solely on the basis of an alert circular, because he has to make his satisfaction, record his satisfaction. It cannot
Wonderfully
be a
put.
borrowed
Yeah.
satisfaction. So
Yeah.
in this context, I see that appears will play a different role in different proceeding. Whenever it is originating from 61, it is originating from 67, it might originate from 62 and 63 also. It might
Wonderful.
originate from 65 also,
So,
66, 67, 70, 71. So we have
correct.
to read appears in different contexts in which the proceedings have been initiated or ought to have been initiated. And once they have been initiated, then the satisfaction of the officer has to be there about the process he has followed, and then the established criteria has to be seen.
Yes. Sir, there are two things, sir. One, Mailarji has raised on the degree of satisfaction is having a different view. B.S. Mailarji has, held that it is higher than the reason to believe, something less than beyond doubt. So is what the Mailarji is trying to place the contention. Even we try to verify what is the exact degree of satisfaction for the term appears to. I think we have some references. Right now I don't have. I'll take you and give in from the 6th council meeting to 12th council meeting. The word appear, what is the degree of satisfaction is also being discussed somewhere, that the word appears to imports a lesser threshold as compared to reason to believe is what it is been written somewhere. I will exactly take that and I'll tell you, or some decision we have gone through this also. It is lesser than the reason to believe is what the courts have also interpreted. And on the Arpit Ji's point, exactly as he rightly pointed out, the entire fulcrum of the point what he is trying to press is centered on the issue whether it should be on the borrowed satisfaction or not. Exactly, I just want to discuss on the qualities of a satisfaction. That is the point which I'm going to discuss. The next phase of discussion is going to be on the qualities of a satisfaction. How a satisfaction has to be recorded. Here you have one administrative law decision of Supreme Court in the case of Amarendra Kumar Pandey versus Union of India 2022-12 SCR 223.
Your
If
screen is not shared.
1 minute, sir. Yeah, I'll go. Yeah, I'll take you there. Sorry, I'm really sorry. One minute, sir. Sir, is the screen visible, sir? Yes. So this is the decision. The Supreme Court has enunciated the conditions for a valid satisfaction. How a satisfaction should be recorded by the officer. Whenever the word satisfied is used, is of the opinion is used, whenever the word reasons to believe is used, how a satisfaction has to be recorded is what the Supreme Court says. First, it says a prescribed procedure for formation of opinion. The due process for formation of opinion should be followed. The authority should have acted bona fide, and there should not be any borrowed satisfaction, and it should not be proceeded under the misconception of the law. Only on these counts, if the satisfaction is there, these are the conditions for the valid satisfaction. And as you rightly observed, Arpitji, the court has also power to review the satisfaction which the officer has recorded. And how the satisfaction will be reviewed, it will be on the 5 grounds, is what the Supreme Court has said. One is the test of jurisdictional fact. Second is the test of man of reasonable prudence, or we can call it as a reasonable nexus test. The third test, I'm just giving the name. It is not present in the decision, but the 5 test is present. I'm just codifying the names for them. One is the test of jurisdictional fact, and second is the test of man of reasonable prudence. Third is the test of error of law, and fourth is the test of purpose, and fifth one is the test of relevance. So 5 test has been initiated. On these 5 grounds, the Supreme Court can review the satisfaction recorded. What is the exact facts of Amarendra Kumar Pandey? See, Amarendra Kumar Pandey belonged to Assam Rashtriya Rifles, Assam Rifles, and he received 4 disciplinary proceedings were recorded against him. What we call it as red ink. So red ink was received by him. 4 red ink was received by Amarendra Kumar Pandey. On receiving it, the proper officer of the act passes a discharge order. By giving a notice, he passes a discharge order. During his tenure of service, he's been expelled. On being expelled, he now challenges the order of discharge before the Guwahati High Court. And Guwahati High Court says the satisfaction need not be recorded in the notice, and that is being overturned by the Supreme Court in the case of Amarendra Kumar Pandey versus Union of India. This is the broad facts. And while going through the satisfaction recorded by the officer, the court is, concerned about the high-handedness of the power that is given to the administrative officer. That is where the court is saying it would loathe to proceed with such sort of a satisfaction, which has there can be a satisfaction based on evidence, there can be a satisfaction without an evidence, there can be an allegation without an evidence, and there can be an allegation with evidence. It is trying to compare the two, and it says where there is an allegation, it is simply written in the order of discharge. Is conduct so indisciplined that we are passing the order of discharge against the particular officer. So where this is an allegation without an evidence, that is where the court is coming up and saying a satisfaction should circumscribe within these 4 conditions, and court will review the satisfaction on the 5 grounds. One is the test of jurisdictional fact, and second is the test of reasonable nexus between the purpose and the inference drawn by the officer, and third is the error of law. Even if there is a misconception of the law, the court can review the satisfaction and it has the power to correct the action taken by the officer. And fourth is the test of purpose. What is test of purpose? Which is very common. You can, where time limit under 73 is expired for 2A 3B difference or 1 versus 3B difference, the officer is resorting to 74 just because the time limit is expired. To avoid embarrassment from the higher officer, he is venturing into 74. Then you can definitely record, you can challenge his satisfaction and say it has no purpose. The action taken by the officer, the satisfaction recorded by the officer, but the court only has the power to review, is what these are the propositions that are laid down by the Honorable Supreme Court. So the satisfaction is circumscribed by the 4 conditions. Due process should be followed, and the second point is it should be a bona fide action, and there should not be any borrowed satisfaction, and there should not be any misconception of law. Court has the power to review. Review will happen on the 5 grounds. So this is exactly the point which I was supposed to cover. And next issue which I just want to discuss is on the second language that has been adopted in section 74. So when I venture into section 74, the word appears to, these are the conclusions I have drawn on the word appears to. 1, it refers to certain degree of satisfaction, for which we have relied upon several decisions. And second, what is the degree of satisfaction that is required is less than that of a proof. And it's a word appears to is a term of a lesser threshold as compared to the word reason to believe. I can support you with some minutes extracts as well as with some decisions on it. And that after having understood the degree of satisfaction, how the officer should have acted to arrive at that satisfaction, he should have followed the process of law, and the satisfaction should be, it should have acted bona fide in a bona fide manner, and it should not be a borrowed satisfaction. There should not be even a misapplication of law. If anything is there, the court has the power to review on the 5 grounds, and it will review it, and it can what? Correct the action taken by the proper officer. So this is the point we have seen with regard to the word appears to. Appears to, after having understood this, now let me move on to the second expression. Section 74, as I rightly said, it is adopting the word appears to, and it is categorizing 5 cause of action. 1, tax not paid, short paid, erroneously refunded, where input tax credit has been wrongly availed or utilized by reason of fraud or willful misstatement or suppression of facts to evade tax. Again, there is a departure in language. If you refer to section 11A or 28, it uses the word intent to evade tax. But when it comes to section 74, it uses the expression to evade tax. Is there any material difference between intent to evade and to evade? Suppose I just want to suppress my turnover, but all my turnover are exempted supplies. But for some reasons, I just want to suppress. And the authority, based on the search, they are identifying there are some second sales, unrecorded sales in the, they maintain in their diaries, and they are seizing it, and they are taking up the statements. The taxpayer is also agreeing, but they are saying everything is an exempted sale. Just to avoid income tax, I have done this. Now my question is, is there an intent to evade tax? There is an intent to create certain malified intent is present. But when it comes to exempted supply, since there will not be any tax, evasion actually that has happened, 74 cannot be pressed into operations for exempted supplies. Now the word intent is absent here in section 74. Whether it is going to cause a big trouble or the position of the earlier laws will remain the same? That is the second question which I just want to go through it.
Ashwin, I think the second question we'll have to take up on some other day because now it's only
Yes, sir.
10:01.
Yes,
So
okay.
I think
Okay.
it will be a homework for all of us, the diligent students of SMS, to go through
Yes.
the second part. I think, in fact, you have taken out a very small but a very significant point, which is whether the absence of the word intent will change the
Course of
significance here. Yes.
section 74. Yes, sir.
Yes. So I think that is something that we'll deliberate, and maybe we'll take another time for you, another suitable date from you, and then we'll again have this second part of the discussion on that particular day. So for today, we'll have to stop here because time stops. So I would go over to Arpit Haldia ji for a quick conclusion on this, and then we'll offer the vote of thanks.
Thank you, Rupji, and thank you, Ashwin. And as I always say, that as we move towards more and more developed GST law, then the litigation would not be between 3B1 and 3B2A. It would be the nuances of the law and how we read and understand a particular term. As you have said that how the appears term have to be read, and then the absence of intent to evade tax, and going forward in section 74, the placement of dash between willful misstatement and suppression of facts. So that is how the litigation would move ahead, and this is how, and this is the very purpose of SMS also, to delve into the topics which are somewhere with require more application of mind and more interpretation of the law, and that is how we develop as a professional. So thank you very much for a detailed session on the term appears and what is the legislative intent, and very aptly you have covered the scope of appears from the judgment of Honorable Apex Court, that which are the 5 tests which have to be applied wherever any satisfaction is to be recorded, because then again it becomes an absence of jurisdictional fact which can be challenged at any forum, even through a filing of writ petition, if no satisfaction is recorded. So the 5 tests we have laid down would be helpful for all of us whenever we are reading through a notice and wherever we are going through the satisfaction being recorded in context with the appeals which is there in section 73 and 74. And this was a great session and learned a lot from you. Thank you.
Thank you. Humble, sir. Thank you. Thank you for this opportunity. Always grateful
So
to.
thank you,
Thank you.
Arpit, thank you, Ashwin, as always, for the wonderful sessions that we have. Thanks to all the participants for joining in. So as we have shared, the second part of this deliberation will continue it forward because for 21st and 28th, we already have volunteers as speakers. So post that, we'll take a date from Ashwin and then I think we'll take this forward. So thank you very much and looking forward to a wonderful week ahead. Thank you.
Thank you, sir.